Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome back to Law, Life, and Liberty with Anthony Puopolo. Anthony is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he represents clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosbey, your host, and today we're talking about what happens at an arraignment in Massachusetts criminal court. Welcome back, Tony.
Thank you, Lisa.
Tony, when someone is charged with a crime in Massachusetts, what exactly is an arraignment and where does it fall into the criminal process?
So the arraignment is the first step in the criminal process in the Commonwealth of Massachusetts after what we call probable cause has been found to charge a person with a crime. At arraignment, it's a formal reading of the charges against you. So, for example, you may be called and the clerk will stand up and say, John Smith, you are charged on August 27 of 2025 with operating a vehicle under the influence of intoxicating liquor in the town of Hudson. Next, the judge will say, a plea of not guilty has been entered to protect your rights. You will be appointed an attorney if you don't already have one with you. You will be appointed an attorney even if it's just for bail only, just to make sure that you have someone there to represent your interests. At that time, the prosecutor, or what we call the assistant district attorney, representing the Commonwealth of Massachusetts, will tell the judge what they want in terms of if they want bail, if they want conditions of release pending trial, if they want you detained prior to trial, or if you should just be released on what's called personal recognizance, which is simply your promise to return to court on your next scheduled date.
So it's very similar to what we see on TV, really.
Yes, very much. Often, actually, I laugh when I tell people Law and Order typically tends to get it right about 95% of the time. And the 5% of the time they don't, it's just because getting it right would be boring.
So, Tony, for an arraignment or at an arraignment, does the judge describe guilt or innocence, or is the hearing focused on other issues?
So arraignment is focused solely on whether or not you would be released on conditions, released on your promise to return, or held pending trial. There's really very, very little discussion at arraignment about the actual underlying facts of the case. In extraordinary circumstances, I've had where a case was so clearly without basis, I've had an ability to kind of argue for dismissal prior to arraignment. But arraignment is very much focused on what are the reasons, what are the factors which bear in your favor for release, either on your promise to return or with certain conditions, not the actual underlying facts of the matter.
And one of the biggest concerns people have is whether they're going to be released or held. How does the court decide things like bail or conditions of release at that stage?
So there are a variety of factors that are going to be considered at arraignment. First is this a crime involving violence where the prosecutor may move for pretrial detention? Which there's a statute, we call it a 58A hearing or a dangerousness hearing. So things like assault with a dangerous weapon, assault and battery with a dangerous weapon, assault and battery on a family or household member. People are used to, rape and murder, people are held. But there are lesser crimes where the Commonwealth can move for pretrial detention. So the nature of the offense is one of the biggest factors. The facts of the offense, just because you're charged with an offense that may be considered violent, doesn't mean the facts rise to a level where the prosecutor is going to move for dangerousness. So assuming they don't move for any kind of dangerousness hearing, the next thing we're going to look at is what are the underlying facts of the case? If the case seems to be driven by alcohol, the prosecutor may ask for what's called a scram device, which is you have to carry around a breathalyzer with you at all times, and it will randomly go off and you'll have to take a breathalyzer. They may ask for you to have to randomly come to court and take a breath test. Similarly with drugs, if the case involves drugs, you may be required to come to court and do drug screens. You may be required to enter into substance treatment and substance evaluation. If mental health is at issue, you may be required to maintain your current mental health. You may be required to engage in a mental health evaluation. Or if you have, particularly if you have a criminal history, and especially one that involves you not showing up to court, then the prosecutor may ask for bail, which is a cash payment that you make to the court, which incentivizes you to come back. Bail is not intended to be punitive. It is only intended to make sure that you are monetarily incentivized to come back to court. And the facts of the case do bear into whether or not they'll ask for bail. If you are charged with a crime that has a potential of 20 years incarceration, you may want to flee. So they may ask for bail in that situation. If you're a person without strong ties to Massachusetts, I had a client once who picked up a domestic violence assault with her significant other while they were driving through the Commonwealth of Massachusetts. They didn't live here. So they, in that case, a GPS monitor was ordered and she had to stay in the Commonwealth. So there are a lot of factors that are going to be looked at in determining what conditions or bail will be set.
Tony, let's talk about the prosecutor's role during an arraignment, and how does the defense respond to that?
So the prosecutor, or also called the assistant district attorney, represents the Commonwealth of Massachusetts in the proceeding, or if you're in another state, they represent the state. They are a member of the executive branch, whereas the judge and your criminal defense attorney are members of the judiciary. They are essentially there representing the interests of the state. So just because they say they want bail or they want conditions doesn't mean the judge is going to rule on that. They're just there, just like any other litigant, asking for what they think their client, in their case, the Commonwealth, wants. So the defense will typically, the way I handle an arraignment, I will go to the prosecutor before we're in front of the judge and say, what are you looking at on Susie Smith's case? And they'll say, no question of bail. Or they'll say, we want Susie Smith to have random alcohol screening. That helps me prepare for what I'm going to argue. And I may say to the judge, well, Susie Smith's criminal charge doesn't involve alcohol, so an alcohol screening is not appropriate. So having that communication and being prepared for what the Commonwealth is going to ask for and talking to your client about that in advance is very helpful to craft your arguments to a judge.
And in Massachusetts, are there situations where a case can actually start moving towards dismissal or resolution as early as the arraignment?
Both. Although it is extremely rare to move towards dismissal, to have a criminal case dismissed at the district court level in the Commonwealth of Massachusetts, the application for criminal complaint or the police report that was submitted to the court for the charge cannot have probable cause within the four corners of that document, which essentially means if a reasonable person read that police report and didn't believe a crime reasonably were likely to have happened, then the case should be dismissed. It's very uncommon, but it does happen. In an extreme circumstance, I've had that happen before arraignment. It's only happened really twice in my career where I've had a police report that was so deficient that I raised it to the judge before the arraignment occurred, and the case did ultimately get dismissed prior to arraignment. But typically, if you believe that there is lack of probable cause, you would schedule the next date to be a motion to dismiss. As far as resolution, I never recommend any kind of a plea prior to, particularly at arraignment, but rarely before I've received the evidence from the prosecutor. But it has happened where I've had defendants who were adamant. I had an operating under the influence charge once where the gentleman said, I did it. I know that the proof is going to say that I did it. I was drunk. I don't want to drag this out. I don't want to come back here. I just want to plead today. It's never going to be your lawyer's advice to do that, but it is always your right. If you say, I want to plead today, and the prosecutor is willing to proceed, which would only happen as long as there's no alleged victim they have to reach out to, um, then you can plea even at arraignment, although it's not advisable.
Interesting. How important is it for someone to have a lawyer with them at the arraignment? You said that one can be appointed for bail reasons to make sure that the individual is represented. But rather than trying to handle this first appearance alone, do you accept that or do you try to find your own attorney beforehand?
If you have the opportunity to find your own attorney beforehand, in the situation where maybe you got an arraignment, a summons in the mail versus you were arrested and brought directly into court, you should absolutely try to find an attorney in advance for multiple reasons. One, anything you say in that courtroom can and will be used against you. And despite their best efforts, the average member of the public's first instinct is to try to explain why they are not guilty, to try to argue the facts of the case and not what the court cares about in that moment. And everything you say in that room is recorded, and it can be pulled later and used against you. Because human memory is going to change over time. And if you say the ball on the ground was blue at arraignment, and then at trial you say the ball on the ground was purple, the prosecutor, even something as simple as that, the prosecutor is going to try to make you look like you're a liar to the jury because, well, you said it was blue before. Which was it? Is it blue? Is it purple? If you can't remember something that basic, how can you possibly be telling us the truth about everything else? So it's really important. Also, you don't know the rules and the procedures. Lawyers have spent years, if not decades for some of us, practicing in this area, learning about this area. We know the ins and outs that will trip you up. And if you go in by yourself, a judge will warn you that you are expected to know the law just as well as if you were a lawyer. So if you can't afford a lawyer, the court will appoint an attorney to you. But if you can afford a lawyer, you should hire one well in advance of that arraignment if possible.
And Tony, what kinds of conditions might the court impose after an arraignment while the case is pending?
So the judge is tasked with setting conditions that can reasonably assure the safety of the alleged victim and the public. So things like if the crime seemed to be alcohol involved, they can order no alcohol with random screens. Same thing with drugs. Any kind of domestic violence situation, or typically violence in general, there's going to be an order that you stay away from and have no contact with the person alleged to be the victim of that crime. Your passport can be ordered to be surrendered if you're a flight risk. You could arguably be subject to GPS monitoring and or GPS lockdown in a home. In earlier, when I mentioned those kind of dangerousness hearings where the Commonwealth is asking for a person to be held, usually my go-to defense there would be to ask the court to consider GPS home confinement as an alternative to jail confinement. So the judge does generally have a very broad discretion to determine what conditions are appropriate to ensure your compliance with court orders.
Tony, let's wrap this all up for our listeners today. For someone who has just been told that they need to appear for an arraignment, what should they do to prepare before walking into court?
So if you received a summons arraignment in the mail, retain an attorney as quickly as possible. That attorney can go to the court and get the police report which was filed with the court to get the charges issued in the first place. That way you know what you're facing. A lot of people might know exactly what they're charged with, but may not have all of the facts that the police report contains. And those can be very important because in, say, for instance, in a domestic violence situation, both parties are going to be separated. They're going to be interviewed by different police officers, which means you may not know what the other person said. So it's important to get that report because you may have evidence that that person is not telling the truth. Which can be relevant if the Commonwealth ultimately tries to have you held pending a trial. Getting that report gives you the ability to start gathering what evidence you may or may not need. And in addition, it lets you know whether or not you need to be prepared at all. If you've just received notice in the mail of an arraignment, it's important to retain an attorney right away. That attorney can go to the court and can get the police report that was filed to have the charges issued. That police report is going to contain the information that you're going to need to prepare your defense. You may not know everything that was in that report. You're going to know likely what you communicated to the police, but they may have done other investigation that you're not aware of, that you may have evidence that is relevant for you for arraignment purposes. Often, an arraignment is not going to involve any kind of formal evidentiary hearing, but if the prosecutor is seeking to have you held before trial, you are entitled to an evidentiary hearing, so it's important to prepare for that. Otherwise, you're going to be talking to your lawyer about your ties to the community so that your lawyer can say, John Smith is, has worked for Raytheon in their missile production for the past 30 years. They're not going to flee the Commonwealth. They've got a child, they've got grandchildren. Those are the things you're going to want to talk to your attorney about so that your attorney can convey this to the judge and explain to the judge why you should just be ideally released on your promise to return to court.
Thank you, Tony. This has been very insightful. I appreciate you breaking down each of these steps and what's involved in an arraignment. Folks, that's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about attorney Anthony Puopolo and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.